Hello, welcome once again to Lehto's Law. I'm Steve Lehto. Today we're going to discuss what the common law is, and of course I'm wearing the 101.7 The Wall shirt. Coming up shortly, an announcement, but hopefully I'll get to do my return to radio as a DJ with 101.7 The Wall, which has been Finger Lakes' only classic rock station for 20 years. Of course, the Finger Lakes area of New York, a beautiful area where 101.7 The Wall teaches us how to shut up and rock. So soon. But today, like I said, common law on Lehto's Law. And I had Peter ask me about this, and he said, Steve, what's the deal with common law? What does it mean? And I've talked about it before, tangentially, as we say, but I've never actually discussed simply what it is. And it's kind of funny because this area confuses a lot of people. We've all heard the phrase common law, and you'll often see sovereign citizens in court if you watch the videos where they will challenge the judge and say, Your Honor, is this a common law court? And judges will often actually just look at these people with sympathy and just go, but how do you want to plead, guilty or not guilty? And so the question is, of course, what is common law? So I'll let you know that I've often joked about the books behind me on the shelves. One of them is A Concise History of the Common Law, written by a guy named Plucknett. And if you ever want to read it, Theodore Plucknett came out in 1956. I can't really say how concise it actually is because it is actually far from concise. And I can't say it's exciting reading either. It's a little bit dry. But one of the interesting things about it is the guy goes back to the earliest mists of history to show us where the law in our world comes from. And by our world, I'm referring to Western society and the parts of it that use the common law. And he points out at the very beginning is that, we don't really know where anything came from. I mean, the further back you go, to realize you can go back even further, So the idea of where our law came from in itself is actually kind of a thing shrouded in mystery. But what common law is a reference to is that in England, where we got a lot of our stuff from, including our English language, in England, they would have a system where there were courts, and the courts enforced the law. And much of the law they were enforcing was not written down. It wasn't statutory. It wasn't where someone passed a law and said, if you break this law, you will be punished. And so what happened over a long period of time, the courts had jurisdiction to enforce laws that were simply laws that had been enforced previously. And it was basically based on precedent, judicial rulings. So in other words, if you were before the court and they said you are charged with murder, you're charged with murder, they wouldn't pull out a law book that says here is murder and here's how you define it. They would pull out case law and find a case that said, here we found this person guilty of murder because of this, this, and this. And it's the law, and the common law was that murder had certain elements to it. And those elements had simply evolved over time. And so the word common in the phrase common law is not a reference to, like, say, commoners or anything like that. It's the fact that common also means that something is everywhere. It's ubiquitous. It's universal. It's that common. So common law merely meant that it was the law of the land, okay? But it was not derived from statutes or ordinances or codes. It was not written down in that way. There was no set of law books that contained all of the laws. Now, we do have them today. I've talked about these law books behind me many, many times. The Michigan compiled laws, for instance, are the laws of the state of Michigan. But how we got to that from the common law is really what we're talking about here. So common law historically was derived from judicial decisions. And we've all heard that before, where you talk about the precedent of a particular case. So to give an example of precedential value, this is not common law, but I'm simply pointing this out, is that if you wanted to discuss abortion in America, whether or not there's a right to have an abortion, you go, oh, that's Roe versus Wade. And everyone knows that there's a case that stands for a proposition. Okay, that's a Supreme Court case. Well, in the old days of the common law, when it came to murder or assault or kidnapping or any crime, those are the easiest ones to talk about, there were often situations where everyone knew that for murder to be murder, the actor had to have done certain things against somebody else who was a victim. And if they'd done those things, they could then be convicted of murder. And those things would have been just restated over and over again in previous cases. Now you might say, why wouldn't they bother to write some of this stuff down? Well, where they, in other words, just make a statute, make a set of codes. They eventually did, but one of the reasons they didn't, at least in the early days, was that many of the laws were considered to be a little bit too difficult to have codified. So we all know that, like, premeditated murder, right? What we now call it first degree murder, but premeditated murder. And then you have the kind of murder without premeditation, which might be manslaughter. And all these are different, subsections of homicide. And so if somebody was arrested because they killed somebody, okay, they killed somebody. If they hired an attorney or a barrister or a solicitor to defend them, what the person would do is look at the facts of the case and then go dig through case law to find out what exactly matched up with what their position is going to be. And then, of course, the Crown or the prosecutor would look through case law to find case law that matched up with what they thought they could prove this person had done. And then, of course, they'd come before the court and they'd argue over it, and they'd come to some kind of conclusion as to which of these laws apply to this set of facts. And you'd argue it and take it to a jury or whatever you're going to do, and eventually come to some kind of resolution. And so over a long period of time, the cases had developed and were recorded. And it's fascinating to read some of the old cases. It's actually can be entertaining on some level, but it's also maddening on another level as the language has changed so much over time. But a lot of this evolves in the field of criminal law and contract law. And again, contract law we think is simple, right? You and I shake hands. You're going to give me $500 and I'm going to sell you these X-ray specs, right? And we shake hands. You give me the $500 and I run away laughing. And now you're going to sue me for breach of contract, right? But the question, of course, is, do you want your $500 back? Do you want the X-ray specs? Are you entitled to more than your $500 back? Are you entitled to the X-ray specs and $500? Are you, and so all of those questions, if you wanted to find the answers to them in the old days, you'd start digging through case law. Or you'd find a guy who knew the case law really, really well and ask him, say, what cases apply to this and what can I get out of this? And when you went into court, you'd present the court with the cases you think that support your position. And as you can imagine, it's actually an inefficient way of doing it because, number one, every time you have a question, you have to go dig through case law. So there were people back then who even started organizing this stuff in some form. Blackstone, we've heard of Blackstone's commentaries. He was attempting to codify this, or at least put some organization to it, to where if somebody had a question regarding one of these things, they could then look at his commentaries and possibly get a head start on which way to go. What wound up happening in America, when we came to America from wherever we came from, many of us, of course, came from Europe and brought over the European legal traditions. And many of the first people here, of course, had come from England. And so the English common law was brought over here and very quickly became our common law as well. And you'd actually hear about, in the early days of the American court systems, even back in the colonies, that there was a push to have the courts record all their decisions so that we could start establishing our own body of case law. So that if it evolved differently over here, we could at least say, you know something, I'm accused of a crime, and the last time this happened over in Boston, here's what happened, okay? And you pull that case law out instead of your fancy pants opponent pulling out a case that happened back in England 300 years ago, and he's going to say, this is still good case law. So we started developing our own case law and our own common law over here. But then what pretty much happened, and this happened pretty much across the whole country, and it depends on where you are, but sometime leading up to the 20th century, there was a push in most states to codify the statutes of the state, codify the laws of the state, and then also to codify contract law. Believe it or not, that happened later. But the first was the criminal law and the statutes of the state. So the Michigan compiled laws are a more recent thing, But we started codifying laws in Michigan where we'd actually say, murder is against the law. And here's how we define it. And we would define it and say, these elements must be present for this to be first degree murder. And if you have all these elements minus this, then it becomes second degree murder. And all of this minus this becomes negligent homicide, or whatever you want to call it. And the point is that we'd have these statutes laying this all out. But those statutes are not common law. But the funny thing is, if you look at the statutes, you'll see that almost all of the elements in there had been addressed at one time or another by the common law. But the point is that we had decided that we don't want this law evolving too much anymore. We kind of like it this way. But the weird part is that it's not uncommon, one of two things, that either something wasn't codified because nobody thought of it, or when we codified it, we simply missed something. And so I've mentioned before that Dr. Jack Kevorkian, who I've met, by the way, he's no longer with us, was prosecuted in Michigan for assisting suicides at a time when there was no law on the books saying you couldn't assist a suicide. So when Kevorkian went to trial, his attorneys argued to the court and said, you guys are prosecuting him for a crime that doesn't exist. And the prosecutors at one point in time actually said, even though it's not on the books, it is common law that you cannot assist somebody to commit suicide. And there was a bunch of back and forth on that, and I can tell you right now that they eventually had to pass a law, in essence, to say that what Kevorkian was doing was illegal, or had become illegal. And then, of course, you have the problem that these laws are being passed here, so the stuff he did back here, he can't be prosecuted for. It's another story altogether. But the point is that they did codify much of the criminal law. And so nowadays, if somebody walks into my office and says, hey, I've been charged with a crime, I ask them, I go, show me the charging document. And I look it up, it goes MCL 750 point, and that's the criminal code. And I look it up and I pull it out and read it and go, okay, here are the elements, boom, 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 boom. And I mentioned earlier the contract law. Contract law was, again, another thing that had derived over the years and evolved from just precedent and court rulings and court rulings. And there'd be famous court rulings. One of the most famous court rulings that anybody's gone to law school was Hadley versus Baxendale. And I might get these facts wrong. It's been 30 years since I read the case. But a guy who owned a mill had something in his mill break. I think it was a crankshaft, actually. And he sent the shaft to a repair facility who had said, we can get it back to you within a certain amount of time. And they failed. And they took too long to get it back to him. They did fix it and they sent it back to him, but it was much later than they promised. And so the guy who owned the mill sued the repair shop and said, when they didn't get me that thing back in time, I lost business. I want to sue them for damages. Even though they did the work they told me they would do, I want to sue them because they did the work too slowly. And the court at that time said, no, you can't sue for that because you didn't let them know that was part of the contract, and they had no way of knowing that you were going to suffer extra damages. And so since the damages that you're claiming could not have been foreseen by the other party, they can't be held liable for them. And many people pointed out that it was simply a good decision from the standpoint of making contracts in a commercial setting very, very efficient. Because if every contract that you entered into with somebody could make you liable for damages that you have no idea that they even could possibly exist, you can imagine what would happen very quickly. The guy with the repair shop's gonna say, I can't repair your stuff because I'm worried I'll get sued for not repairing it fast enough or something. So it was a good decision in that respect, but a lot of people who look at it from the other way and go, wait a second. So these guys screwed up, they cost this guy a bunch of money and he can't recover it? But, the courts picked a winner, and that winner became good case law. And that case was probably cited in, an infinite number of times. This is impossible, of course, because it was simply that's a case that stood for that proposition. And anytime people raised the position, I want damages beyond my out of pockets, Hadley versus Baxendale, and courts often would apply that. So the contract laws in many states were fixed or made, in a written form with the Uniform Commercial Code. And I've talked about the UCC many times on this channel. And the UCC, I often talk about is a sale of goods, Article 2, but there's Article 1, Article 2, Article 3, Article 4, negotiable instruments, Article 9, secured transactions. And there's all these different articles of the UCC. And many of the things they talk about were things that were previously just common law concepts about offer, acceptance, repudiation, rescission, revocation. All of those terms had existed in the common law and had been used repeatedly, over and over again in cases that had gone back hundreds of years. And some of the case law was so well established through hundreds of years of case law that most people would say, oh, it's well established now that for you to repudiate a contract in this setting, you must have these elements. Or for revocation, you must have these elements. And what happened in this respect is that many of the issues that I'm talking about here had evolved slightly differently in different parts of the country. So that you might have a different situation for repudiation in Texas than you do in Michigan. And you might say, so what? Well, there was a time when that wouldn't matter. You did business with the guy at the end of your street, or you went to the village fair to buy your grain, but you didn't do interstate commerce. But nowadays, and even back in the 50s, you could jump on the phone and buy something from Texas. And the guy in Texas does something you don't like, and you're in Michigan, and you want to sue him under Michigan law until you find out Texas law is different. So the Uniform Commercial Code was designed in many respects to make it so that there was one set of rules that everybody was operating off of in the whole United States. And the UCC was adopted for the most part by all 50 states. Some states made minor modifications to it, but the modifications generally are not earth-shattering. So that I can guess that the UCC law that applies in Michigan is probably very, very similar to the one that applies in Texas. And if it's not, I can very quickly look them up now. But the point is that prior to that, I'd have to worry about what the case law was in my state, what the case law was in your state, and hope they hadn't diverged in the past somewhere, because they might have at common law. So the common law was just what we had as a record of precedents behind us, judicial rulings. And the rulings were the body of law. Nowadays, the body of law we have is statutes, codes, laws, and it depends, ordinances. It depends on who passes them and so on, what right they have to pass them. And those are the laws that we have to follow. The federal government derives its power from the Constitution. So, of course, Congress can pass laws, the president signs them into law, and now you've got a federal statute you've got to follow. This confuses a lot of people because these two sets of laws overlap each other, okay? Right now, in Michigan, I've got to live by Michigan state law, but I've also got to avoid breaking any federal laws that cover me while I'm in the state of Michigan. Now, what confuses a lot of people, and I've seen this all the time on the internet, where people go into court and they ask the judge, they go, Your Honor, is this a common law court or not? And they think they've got the judge on a technicality. And I've seen judges try to explain it to people, and I've seen people who clearly don't understand what that means because it's a dumb question. The court is just a court that's established by the Constitution. And yeah, some of what they do probably is common law, but what they also do is enforce statutory law. But there's no law out there that says common law must be enforced in one court and statutory law is enforced in another court. And if you want to find out where the courts derive their power from, you look to the Constitution. Article 3, and I'll read it to you just in case you're curious. Section 1, the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. So I've had people say, well, Steve, I went into a state court, and I said, are you an Article 3 court? Well, no, of course they're not. Why would they be? That's a state court. Article 3 says the judicial power of the United States shall be vested in one Supreme Court. So Article 3 courts are federal courts, and federal courts enforce federal law. So if you break a state law, you get brought into a state court. And you'd have to look at your state constitution to understand where that derives from. And so Michigan has a section of its constitution that parallels, in many respects, the federal constitution, which says, there is a Congress. Here's what it is. There is an executive, governor. Here's how that works. And then there is a Supreme Court, and here's how that works. Same thing. Michigan Supreme Court at the top, and then down below, courts of appeal. Down below them are the trial courts. And the trial courts might be circuit courts for the counties or district trial courts for the municipalities. And all of that's from the Constitution. So when you walk into a state court and go, excuse me, are you an Article 3 court? No, state court. This is a state court. You're charged with state crime. And the Constitution, I think, allows states to do what they want within reason. But Article 3 courts are federal courts, and the state courts are state courts. And by the way, in case you're curious, people say, well, so what about this common law issue and the federal courts? Well, remember that common law, generally speaking, is state law, okay? And I believe there have been cases that talk about whether or not there was federal common law. But for the most part, when we're talking about common law, we're talking about state law, the laws that are enforced by your states, and those that evolved over time. So getting back to the very, very beginning, common law is a reference to going back long before we'd actually written down all of our codes and statutes. And it was simply the fact that to find the law, you would look at previous judicial rulings. And by rulings, I'm not talking about the court found in one person's favor or in the other, but the courts would often write an opinion explaining how they found what they found. And that opinion would explain what they looked for. So to find this person of murder, we found that they did in fact do this, 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 and this, and this defense of theirs didn't work, and here's why. And that opinion then gets published in a book, sits on a bookshelf someplace, and years down the road when somebody has a similar case, they dust it off and they read it and go, does this help me? Does this hurt me? And if it helps me, I go into court and I wave it around. If it hurts me, I close it quickly and go find another one. But that's what common law is. And so is the court you're standing in a common law court? It's a federal court? No. It's an Article 3 court of the U.S. Constitution. State court? Yeah, it's a common law court. Common law might come up, but generally speaking, most of our laws are now written down someplace. And that means that we don't rely on common law as much as we used to. Questions or comments, put them below. Otherwise, talk to you later. Bye-bye.